Police received a box of Hornby .40 caliber ammunition, an AR-15 magazine, an AK firearm with a double magazine, an AR-15 rifle with a magazine and shell catcher, an AK hell pup with a magazine, a Glock 17, a .40 caliber Glock magazine, a 9mm Glock magazine, and a Glock 22 handgun.
Case People versus Dean Bransford.
Good morning, Your Honor. Trovia Starr, on behalf of Mr. Bransford, the Bransford Station.
Dean Bransford.
Thank you. Your Honor, a few things here. One, we would like to set these matters, because there are two matters, for exam.
Okay.
Two, we would like to address bond. And third, depends your decision. Well, there's another bond issue as well that we'd like to address separate from this case. That's before you.
All right. What date am I on? All right. When people have their witnesses available, July 7th. All right. Discovery is complete.
Discovery is complete. Is it possible to have July 14th?
Any objection from the preliminary examination in person will be set July 14th, 2026, 9 a.m. before Judge Garwood. As to bond.
Yes, Your Honor. One moment. I believe Mr. Bransford's bond right now is $50,000, 10%. $50,000, 10%, I believe. We're asking if possible if the bond can be reduced. Mr. Bransford is 25 years old. He has a child on the way. If he's out, he'll be able to do his job at Taco Bell, and he'll be living with his mother. We understand the allegations in this case, and that these are two felonies, and that he has other matters as well. We're asking if possible if this bond can be reduced from $50,000, 10%, to $10,000, 10%.
Response.
It's not an issue, Judge. I'm sure the court is aware the last time Mr. Bransford was here, his jail calls were addressed in which he was calling the victim directly and having others call on his behalf, saying that Dee said, tell your mama to tell that his mama will pay her to write the judge and tell him that you're going to do that. Is there any way someone can take back what they said to the police, saying that to the victim?
This bond request immediately runs into a problem far more serious than the amount of money proposed by the defense. Counsel emphasizes Mr. Bransford's age, employment, housing with his mother, and child on the way. All traditional community ties arguments intended to show stability. But the prosecutor answers with alleged jail calls, suggesting direct and third-party efforts to influence the victim. For Judge Simpson, that raises both public safety and court order compliance concerns. A defendant does not need to physically threaten someone for alleged witness interference to become relevant. Attempting to shape, retract, or suppress a statement can undermine the integrity of the prosecution itself. Notice the prosecutor also carefully says the conduct requires further investigation and could potentially be added at the preliminary examination. That language distinguishes an allegation from a proven new offense while still giving the court a reason to deny greater freedom. Reducing the bond from $50,000 at 10% to $10,000 at 10% would substantially lower the release barrier. Would employment and family support outweigh evidence that he may have used custody calls to reach the victim? Judge Simpson's denial indicates they do not.
So I would have concerns that he can't follow court orders given that he was in custody, potentially committing witness interfering. That needs a little bit more investigation and could potentially be added at exam for Mr. Bransford. So at this point, I'll be objecting.
Anything else?
Nothing further on this second issue.
Motion for bond reduction is denied.
And then finally, Your Honor, 261071 SM, that's a misdemeanor matter. It's not up for today. I will be sending over a stipulational order to increase his bond on that.
And I read this before, Your Honor. I think it's figured out for assault at the jail. I'm sure.
So someone posted bond in that case. So he's not receiving credit on that particular case. So I'm submitted.
All right. Well, it seems to me if you talk to the prosecutor on that, you can deal with that. All right. Thank you.
Thank you. All right. Good morning, Your Honor. Again, Trovia Starr on behalf of Mr. Hunter Jr. Mr. Hunter Jr., state your name.
Andre Hunter.
Your Honor, My client is urging me to set this matter for an exam. Discovery is not complete. I should be okay, but discovery is not complete.
What's missing?
Well, I was just appointed to this case yesterday, and I made the discovery request, and I've informed.
You don't have any.
I don't have anything. I've informed my client that the best way possible is to adjourn it so I can get the discovery.
Who had the case before?
The PD's office. They did send me something, but I just got this case yesterday late afternoon. But again, my client is urging to set this matter for an exam.
Is that correct, sir?
Yes.
Understanding that your attorney may not be ready?
Yes. And when appropriate, Mr. Hunter would like me to address bond as well.
I'm going to mark in the file that there'll be no adjournment for any discovery issues. That's going to be on you guys. People have their witnesses available the 7th or the 14th. We're going to have to go to
14th would be great. Thank you.
Preliminary examination in person, July 14th, 2026, 9 a.m. before Judge Washington.
Your Honor, I believe Mr. Hunter's bond right now is no bond. Mr. Hunter, he's 33 years old. He has a total of 4 children. His family is in the courtroom. He resides with his children, his girlfriend, himself, of course. He works for construction with his uncle. I believe he has a violation of probation case. Yeah, I know he has a violation of probation, I believe related to this, but I'm not sure. And I was just appointed to that one. That's up on July 7th in front of Judge Conkey at the circuit court. We were asked that.
Where do you get no bond?
That's what my client told me.
Well, he's obviously not telling you the truth.
But what is his bond, Your Honor?
It's 1,000 cash surety.
I'm sorry, say that again?
1,000 cash surety.
Tell them I already paid 1,010%. $10 and I was supposed to get a tether.
Oh, okay. Your Honor, I would ask if the bond can be amended to a 10%, $1,000, 10% along with the tether.
Any response on these charges? Any response from the people?
They even said anything about self-defense.
Over here for Miss Fortin.
Application.
Say the Fortin.
It already is.
110.
I don't know why you're wasting my time. His bond is already 1,010%.
Told me I was
Motion for bond reduction is denied. I don't even know why we had to hear that. Thank you. We're done.
This exchange shows how quickly a bond argument can collapse when counsel has not verified the existing release terms. The defense begins from the premise that Mr. Hunter is being held without bond, then learns that the actual bond is $1,000 cash, and finally requests $1,000 at 10% with a tether, apparently not realizing that the court's record already reflects substantially the same percentage-based amount. Judge Simpson's frustration is therefore procedural, not simply personal. The court has spent time hearing a motion that does not identify a meaningful change requiring relief. The earlier scheduling discussion makes the problem sharper. Counsel was appointed only yesterday, has incomplete discovery, and nevertheless proceeds because Mr. Hunter insists on an examination date. The judge expressly warns that there will be no later adjournment based on discovery problems. That creates a strategic risk. A defendant can demand a prompt preliminary examination, but doing so may leave newly appointed counsel with less time to review evidence, investigate defenses, and prepare cross-examination. Did Mr. Hunter's urgency actually advance his interests, or did it pressure his attorney into making an avoidable factual mistake? The broader lesson is that courtroom requests must be anchored to verified orders, not a client's recollection of them.
$1,000. Heard from me, it's $1,000, 10%.
I'm sorry, it's set. Correct you?
I said it. Yeah,
Number 14.
Okay, so sorry.
that's all right. 14th before Judge Washington, I think.
Thank
Court calls case people.
And Mr. Pitts, if you could please say your name.
George Pitts.
Your Honor,
All right. Yes.
thank you. Today is the date and time for the PCC and also for hearing on a bond motion I filed that is regarding a funeral. We are asking to set this matter for exam.
Is discovery complete?
It is, Your Honor. It appears to be complete.
People have their witnesses available the 7th?
Yes, Your Honor. We'll do about
All right. Preliminary examination will be set July 7th, 2026, 9 a.m. before Judge Freshour.
Your Honor, if I may, the co-defendant's case was also set for exam that day before Judge Perry. Would it be possible to keep these two cases together? It would be the same. Oh,
Yes.
thank you.
We'll do that. So the co-defendant's already been sent before Perry.
That's correct, Your Honor.
All right. So we'll make this before Judge Perry. And then as to bond, did you
Your Honor,
go ahead?
a family member died and the funeral.
Yes, go ahead.
I believe my client's family member's funeral is tomorrow. So he is asking that he may be allowed to attend his loved one's funeral and say his last goodbyes.
I don't. Any response from the people? I don't know. Did you get a copy of this motion?
I do not have a copy. If there was a written motion filed, I do not have a copy of that. I'm checking as I saw on the docket, it looks like it was a motion set. I did not see one in our file nor in my court, so I was unaware of what exactly the motion was. Regardless, I would be objecting to any change or release at this time. This is a case where defendant, along with a number of other individuals, were fleeing from police and what I believe ended up being a stolen vehicle after a shooting out of county that 120 miles an hour on the highway past them on the right, going through the red lights. When police eventually found the defendant after they fled on foot from that vehicle, he was hiding in an apartment. I would also note that this defendant has numerous prior convictions that give me reason to believe that he is a danger to the community. I'm seeing as far back as 2016, I believe. There's a felonious assault. I have convictions for, excuse me, scroll down under CCW, receiving, concealing a motor vehicle, malicious destruction of police and fire property. Those were 2023, felon in possession of a firearm. 5, it looks like. There's another conviction, or sorry, no, those were just found over. I don't know what the disposition of those charges are, so I'll leave those off. At 2026, the defendant has a fleeing and eluding in 3rd degree, as well as a recent CCW conviction. So I have concerns that this defendant proves to be a flight risk as well as a danger to the community. I sympathize with the defendant and the loss of a loved one if I don't believe that release is appropriate at this time.
Your Honor, and my client currently is not facing any type of charges alleging that he fled from police. My understanding is that the arrest was in an apartment building or apartment complex.
After they got out of the car and ran to it, and the police followed them there. I realized they may not have charged that, but
well, Your Honor, all I can say regarding the charges is that my client disputes that, but this is his last chance to say goodbye to his brother. And it would seem to me that if he could have some sort of escorted opportunity to attend the funeral, that.
And Your Honor, just for some additional context, as far as the firearms involved in this case, pursuant to a search warrant, police received a box of Hornby .40 caliber ammunition, an AR-15 magazine, an AK firearm with a double magazine, an AR-15 rifle with a magazine and shell catcher, an AK hell pup with a magazine, a Glock 17, a 40 caliber Glock magazine, a 9mm Glock magazine, and a Glock 22 handgun.
All right. I'm not going to let this, I understand and I feel for the defendant, but I'm not going to allow release at this time. His bond will continue. Thank you.
Okay.
So motion is
Thank you. I'd also filed a motion for a team member to go interview Mr. Pitts at the jail.
for who?
An investigator? I think I submitted a proposed order just for them to be able to visit him at the jail to do an interview to assist me because of the volume of discovery.
I don't have a copy of that motion either, so I'm not able to.
So I don't, counsel, I'm not, you got to send a copy of your motion to the prosecutor's office, because this is now the second one that they don't have for whatever the reason.
They're in the email. I sent it to your court and to the prosecutor's office. Both.
She did what?
The prosecutor's office.
So you sent it to the generic email for the prosecutor's office? Didn't get a name?
I sent it to the only email I had for their office.
Okay, well, I'm not going to address, if they don't have a copy, I'm not going to address it because that puts them behind the eight ball because they don't have the information. But so I'm not going to address that motion. All right, thank you.
Thank you, Your Honor. May I ask, do I just send it to the prosecutor that just spoke? Is that the correct individual at this point, or would it be a different prosecutor since it's before Judge Perry now?
Ma'am, you can send it to me, and I can give you my email once we're off the record. I can shoot you an email because I believe I have your email.
Okay, thank you. I would appreciate that.
Thank you.
Have a good day, everyone.
Across these hearings, Judge Simpson consistently separates sympathy and personal circumstances from the legal concerns governing bond and procedure. Mr. Bransford offered employment, housing, family support, and an expected child, but the alleged jail calls created a much stronger concern: possible interference with a victim and an inability to follow release restrictions. Mr. Hunter's request failed for a different reason. The defense had not accurately confirmed the bond already in place, leaving the court with no meaningful reduction to consider. Mr. Pitts presented the most emotionally difficult request. Wanting to attend his brother's funeral is understandable, and defense counsel proposed an escorted opportunity rather than unrestricted release. But the prosecution described alleged flight from a vehicle traveling at extreme speed, an arrest after occupants ran into an apartment complex, prior convictions, and numerous firearms and ammunition recovered under a search warrant. Those allegations are not findings of guilt on the pending case, but they are relevant to the court's assessment of danger and flight risk. Judge Simpson therefore kept the existing bond in place. The final motion also highlights a basic rule of courtroom fairness. Both sides must receive proper notice and an opportunity to respond. Even if counsel emailed a generic prosecutor address, Judge Simpson would not decide a motion the assigned prosecutor had not actually received. Was that a reasonable procedural safeguard, or should the court have investigated the delivery issue further? The practical takeaway is clear. Verify bond terms, serve motions on the correct party, and support every request with facts that directly address risk. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.